And I think a document was circulated. Mr. Richards? The document has been circulated, all right. I said that we need to settle this concept and settle who we can get on the list and what purpose we're going to use that list for, how we can use it. I gather there are a lot of legal questions that I'll have to be guided by about how we use the information gathered if we have them on a watch list, who we should put in it, how we put them on it, and all difficult questions to answer for the layperson. So, and that my Charter of Rights will protect them from my prosecutor. Mr. Richards?
Yes, sir.
You can go.
Thank you, Chairman. So my name is Rohan Richards. I'm the Chief Technical Director in the Ministry of National Security, and I'm flanked by the Senior Legal Officer in the Ministry. To my right, Ms. Paula Wadsworth, and to my left, Mr. Richards Foster, who is the Policy Manager for Organized Defense, as well as my colleagues from the JCF and MOCA. And we all work together to try to pull together the proposals relating to development of the watch list. But just to set some policy context, we are looking at some deliberations which happened from the National Security Council, as well as a pronouncement from the Prime Minister in his sectoral presentation. And the ministry was essentially tasked with developing a logical framework for the inclusion of persons onto a gang watch list who have been suspected of, who have been charged or convicted of offenses under the Criminal Justice Suppression of Criminal Organization Act. And the Prime Minister, in his 2018 budget presentation to Parliament, mentioned the establishment of the gang watch list, and that persons placed on such a gang watch list would be subject to enhanced surveillance and other security measures. So the gang watch list, as we envision it, should enable the imposition of special conditions or restrictions on persons who have been, and we're very careful to point out, charged and convicted of offenses under the Criminal Justice Suppression of Criminal Organization Act, as well as allow for the better management and supervision of persons charged and convicted of offenses under the Criminal Justice Suppression and
There's one regime for charge and one for convicted. Says not charge and convicted.
Oh, sorry, I'm just being reminded. Actually, there's a regime that we're proposing for persons charged and one separate for persons convicted. And as I go through the presentation, you will see.
Three different categories here, so you better approach them in that context. In the presentation, convicted, charged, and suspected.
So, so we have after much deliberation, Chairman, decided that the persons suspected would be very difficult for us to be able to, without infringing on constitutional protections, be able to establish a regime within the legislative framework. So what we have done is to propose utilizing the existing framework for persons convicted or persons charged under two separate pieces of legislation.
Can I just ask for a little clarification? As a layman, in the normal course of law enforcement, police officers will have persons who are suspected, persons of interest, and they will be on their own list.
Could have a gang list.
Yes, wouldn't you effectively, well, I presume that even now there's such a list operating by the police of persons who they suspected and would be following their actions and tracking their activities until they have sufficient information or witnesses to testify on any such activity. So just differentiate between that and what would be specified or in that classified watch list under the
So
regime.
we did give consideration to persons who are suspects, and we thought that it was right that that kind of framework be left to the kind of intel operational work. It doesn't have to be legislated. We won't have a category for suspects that's in the legislation.
No, suspect in terms of, no, suspect of being a gang member or suspect of being a risk to the community. You look at gang members principally under this act.
Yes.
In which case, so there were two. The watchlist I perceive as suspect is somebody who is a member of a gang, which makes him, well, you prove if he's a member of a criminal organization.
Being a member of a criminal organization is an offense.
And that's an offense.
You can be charged for that.
So you can actually charge him.
You can't put somebody on a list as if they were such a felon.
Yeah.
Until that has been proven. So you can legally anyway, but you can have administratively a list of suspects and you know, devise your strategies
and that's,
around
that's intelligence to deal with that, but not a legislated list. Yeah, and that comes from intelligence anyway, just administratively. But if we define a organization, a criminal organization, you may in fact want to put special surveillance on the individual even before you charge him. That's the only condition. That could be, you'd have to go before a judge, as you say, in chambers, demonstrate to them that the individual is a member of the gang, but you don't wish to discharge them on that basis. How would that happen?
I just think any kind of action that is curtailing the liberty of the subject, where they have not been convicted of an offense, you know, it's going to be, you'd have to substantiate that is within the charter, you know, that the measures are justifiable, reasonably justifiable in a free and democratic society, and that the protections to ensure that power is not arbitrarily used or that errors are avoided and so on, all of that would have to be built into the framework. Yeah.
Built in. That should be done for a judge. I'm trying to get the conviction is there. Once there's conviction, it's easy. And if you charge and you have bail, those two are easy to develop a list from that. It would appear there that there could be no. So how do you classify one then who you have enough evidence that they're a member of a criminal organization, which is the gang we're dealing with? You're not prepared to take him into court, no, but you want to put him on enhanced surveillance.
Does surveillance mean you want to put a collar on him or something? Or do you mean you want to watch him closely?
You just want to give the intelligence a legal framework in which to monitor him closely.
So in terms of the legal framework, you mean to have access to things like wiretaps or things like bank account information and so on?
That kind of stuff.
Well, I think
when he's traveling, you can monitor him. You're not stopping him, but you know he's gone here, there.
That may be possible, because we already can intercept it if you go through the proper procedure. You know, you can intercept communication. So it may be possible to design a regime around that. I don't think what you could do is say they can't leave their home or they can't.
No.
They have to wear this.
That's the purpose of watch this. The purpose is to ensure when he leaves, you know. So if he goes to the airport, we'll get a signal that he's traveling, and you can in fact inform your partner that he's come to X place. In other words, be a bit theoretical, but if A is leaving Jamaica on a mission for his gang to acquire firearms in Atlanta, Georgia, and then ship it back out, I'd want to have the authority to, in fact, monitor him in a way that I can use the information as evidence rather than just intelligence. So when he leaves the airport, somebody says, alerts the police, who will alert whoever is our partner in the jurisdiction he's going, who will then track him up there and say, look, he went to number 12, 124th Street. From there, the enhancer, they hear him make a trade deal for X number, and they ship to another force, and you track the whole thing. So you can, in fact, build a network, build out the operation of the gang, but in a legal framework.
So the framework, the things that you would want to be able to do would be, for example, to have an administrative arrangement in place that PICA or their officers that would be obliged to notify you of the person leaving. I don't know if that needs law or not, but that doesn't seem to be a very high threshold of incursion into a person's rights, so that should be possible. Surveillance, phone surveillance, there's a methodology already in our law for that, so that should be possible as well. Access to financial information, there's also provisions in our law for that. So if you want to bring it all together as a kind of basket of things that flow from going before a court and saying, we have strong reason to suspect this person is involved in gang activity, and we want to have enhanced surveillance of the person, and once that order is granted, then you can surveil them. You can't impinge their liberty, but you can do things that are already allowed under our law in individual circumstances. I think that could be designed as a regime.
I don't know. That's really where we want to go, and I don't think that's stopping them moving.
Right. My understanding, my understanding is, obviously the person would not know. If the person knows that he's on the watch list, it doesn't make sense. Correct. So the idea is that there are persons who you believe could be members of a gang, very active, influential,
or
enablers. So you would like the surveillance, you would like the checking on, various institutions, bank accounts, etc., so that you have a good biography, should I say, of that person. So there comes a point when that person may well be charged, but at the time you're doing the surveillance and he's on the watch list, you don't have all the information, but you're gathering information in order to charge him.
And that arrangement should have a finite life.
Sure.
So in other words, you get that window of enhanced surveillance for a period of X days, X months, whatever it is, at the end of which you'd have been expected to have collected sufficient information and evidence that you're going to charge them. Otherwise, that
makes that, I go up, let me give you maybe a better example here, some of which happen locally. You have the businessman who is being initially funded by a scammer. You have that enough information to say to a judge, you're confident that is how this financing came about. He'd become a facilitator for rinsing money and a number of other things that will ensure the gang survives, or the group that he works with survives over time. But where you are, one, you may not want to have enough to really take him before the court immediately. You want to get more evidence, or you have enough to know that he's facilitating the organizers. Secondly, you may want to put in enhanced surveillance to find out all the other members who you may not be aware of yet, or members of the gang. That's the kind of operation you get into. But no, I don't see it going toward restricting, but I don't see it going toward restricting movement. When you restrict movement, they're going to charge. I'd see the charge coming. I'm going to go to restrict movement. I'm going to say, lock him up now and take him to court.
All I'm saying is, either you could just do this in a fragmented way and say, well, you're going to apply under the intercept legislation if you want to intercept. You're going to go under some POCA or the banking legislation if you want to have, or you could have a mechanism through this piece of legislation which says there's a procedure for enhanced surveillance. It lasts, if you get the order, it lasts 90 days or 180 days, whatever it's appropriate and balanced thing. And in that period, these are the things that are available by way of.
From a layman's point of view, non-legal person, I think that's my understanding where we would like to go, where we can put all of these together in one piece of legislation that can do the enhanced surveillance of the relevant individuals, the members of the gang and the facilitators.
Presumably, if in the course of that surveillance you find out that suspect A is in fact in cahoots with B, C, and D, and you want to surveil them, then you'd have to get orders again for them, and you might end up with quite a network of people that you're actually surveying. Yeah.
Minister, we kind of labored over the issue of the suspects, the discussions that you had that you have in the committee now in terms of what would actually define the standards for persons to be considered suspects.
The suspect you're using, you're going to define the criminal organization.
Right.
I think that's where to go now. Do we have enough in the legislation to go to court and define a particular organization? Because remember, in our own circumstances, we have 2A gang from Spanish Town, and we apprehend his leader. But there are many others in the gang. Now, what we need is enough evidence to define the entire grouping called 2A, a gang. So anybody who's a member of that, we can now put the surveillance on. Yeah.
Chairman, may I suggest that we go through this presentation? I do believe a number of questions arises, which will take up most of the time of the committee hearing. So if we would just have the presentation gone through very quickly, and then we can go to the discussion of the issues.
Okay, thank you, AG. So we have looked at what exists now in terms of a current regime for persons convicted. And we realize that for post-conviction, it's already provided for in the Criminal Justice Administration Act. And that act speaks to the maintenance of a registry of restricted persons to include persons convicted under the Anti-Gang Act based on a consequential amendment to that act. And Part 2A of the Criminal Justice Administration Act actually allows for the designation of restricted persons by the minister upon application by the Commissioner of Police, subject to a certificate issued by a judge of the Supreme Court. Section 54B of the Act states that, subject to subsection 3, the minister may, by order, upon application by the Commissioner, and upon being satisfied that it is necessary so to do in the interest of public safety or public order, designate as a restricted person any Jamaican citizen who has been convicted of a specified offense in a foreign state and who is the subject of a deportation order made in the foreign state, or who has elected to return to Jamaica from that state in lieu of deportation. Or B, any person who has been convicted of an offense under the Anti-Gang Act. It also states that any person who is being considered for designation as a restricted person under subsection 1 shall be a person whose conduct and activities have been of such a nature that the minister is satisfied that the person should be regarded as constituting a threat to public safety or public order in Jamaica. And the Commissioner shall, before making an application under subsection 1, notify a judge of the Supreme Court ex parte of his intention to make the application and the reasons therefor, and attach to the application a certificate issued by the judge pursuant to subsection 4. Section 54D of the Act also provides for a central register of restricted persons managed by the Commissioner or his designate. And Section 54D actually states that for the purposes of this Act, there shall be a central register of restricted persons which shall be kept under the management of the Commissioner or such other person as the Commissioner may designate, and the central register shall not be open to inspection by any person except pursuant to the order, by a court. There are certain restrictions that can be placed on the restricted persons, and these include restrictions as to residence, reporting to the police, registration, the use or possession of firearms and other weapons, or otherwise as the minister may deem to be necessary in the interest of public order and public safety. And such restrictions shall be enforced for a period not exceeding 12 months. This is stated in Section 54B(6). Now, we are proposing, for the purposes of the Anti-Gang Act, that some additional restrictions be considered. Restrictions on being, and these are restrictions on being at a specified location or specified locations, restrictions on leaving a specified geographic location, knowingly associating with known gang members, possession of any restricted items including ballistic vests, holsters, tactical vests, and so on, the wearing of electronic monitoring devices, the participation in social intervention programs, counseling, as well as dispute resolution. and of course, mandating the sharing of information with local law enforcement partners. We are proposing that this registry, that there be a subset of this registry that we will call the gang watch list. That is proposal one, and that will deal with persons who are convicted. For persons who are charged, we are proposing utilizing
various pieces of legislation provide for the registry of persons convicted. As part of this proposal for expanded use of a register of convicted persons, has the ministry team done any research on how effectively a register has been used in the past and how it has impacted the fight against crime? Because it's a tool that is already known and that is part of the criminal justice system. We want to know how effective has it been, and if it hasn't worked, why not, based on investigation.
Yeah, based on our understanding, a recent gang member that was recently arrested was actually declared a restricted person and was in fact placed on the list. Arrested. No,
the question is a little broader than that. So we're looking at measures, we're looking at tools that we are going to utilize to be more effective in the fight against crime. Some of these tools are not new. They have been in existence for a while, and no doubt at the time when they were devised and legislated, there was good intention and the expectation that they would work in a particular way. And I believe that as part of this work, we will need to do an assessment of the proposed tool, whether it is new or it is a recycling. And insofar as the tool of a register of convicted persons, right, how effective has this tool been, and what is there to say that merely expanding the category is going to make it any more effective if it has not worked in the past? And when you have placed someone on the register in accordance with the procedure that is set out in the Criminal Justice Administration Act, to what end game? The question is understood. So how will that, at the end of the day, be part of the arsenal? How will that aid? Merely putting someone on a list without more is not going to bring about the results that we're seeking to have.
And then the whole list of additional things that they want to add. These are persons who presumably served their sentences and are now back on the road. So these are persons who have paid their debt to society. And it's one thing to, for example, the sex offenders register requires them to notify the registry of where they live.
But
and
not all gangs. Some of the gangsters who serve their sentence are still, we have other issues that you have to deal with. If you take one who have organized their extortion ring from prison, when he comes out, he has served his time, he due for parole, and he gets parole and come out. And he continues to do his nefarious activity.
Yes.
That's the kind, but again, he's part of a gang.
Yeah.
Who's part of the business there, so.
But I don't know if you can impose on him all of the proposed restrictions.
No, well, in that case.
If he's on parole and license, that's a different thing.
Right.
He could
do
it
not
as
on
a
parole.
condition of parole.
But while
if he's served the sentence and he's now released and he's free, I don't think you can go as far as some of these things about requiring him to wear an electronic monitoring device. And
no, I think you'll have to limit what you do, but we'd like to have him under surveillance. AG?
Chairman, my question is directed at steering us down a path where we use the opportunity of review of the legislation to be extremely mindful of what can work and what can't work, what has worked and what hasn't worked. And unless we understand why a particular tool has not worked, then we may run the risk of going down a path that we have gone down repeatedly without getting the results. And I don't think time is on our side given the enormity of the crime problem that we are facing. So what makes the tool of a registry effective? What are the things that need to be in place?
Registry, explain to me. Eh?
Yes.
What is a register of convicted persons seeking to achieve?
No,
in the case of sexual offenders, it's because the proclivities that led you to be a sexual offender may continue to be part of your psychology.
I can understand for sexual offenders where you need continuous knowledge of where they're going and you're monitoring them. That's certain kind of monitoring, sustained monitoring. But what purpose does the registry of convictions serve otherwise than a record? So I'm trying to get at. In the case of the watchlist, it should become a part of the tool to monitor the activities of a particular person who is conducting himself way that's inimical to the interest of society. But I'm asking, I don't know what a registrar of criminal acts do. What's the purpose of it?
Chairman, through you. Yes, I'm going to suggest we understand a very basic definition of a registry and what it seeks to do, what it seeks to achieve. But we would want to unpack that from the general to the very specific, in consideration of the problems that we are faced with now, in consideration of the information that you may have. What is it about having this registry that is going to prove very effective? It is going to prove that this is something that we absolutely need and will yield the results. What is it about this tool that promises to deliver on what you want?
We're looking at the watch. This is not the same as the registry. Eh? No, it's a different thing altogether. So I was trying to understand what the watchlist is. What a registry is.
We will come back to those who are suspected because that is the biggest challenge based on the data. It is not covered by the presentation, but that is part of what we will have to spend some time looking at. The presentation rightly indicates that there exists a regime to deal with convicted persons. And the question is it adequate? Has it worked? How has it worked? Why use it again? What do we hope to achieve this time?
How have we used this in the past? Because I get the impression it's almost a record, except for sexual offenders, it's a record that we keep. Now,
but even the sexual offenders registry, that has its own set of issues.
In this case, what we are looking for is something that will have to become a part of the tool that we use to monitor the activity of these people who are a risk to the safety of society.
You raised the issue that confronts us, where persons are serving sentence and have access to communication devices and stay on the inside and give directions on the outside. So what needs to be in place in the penal institutions to address that? Because it is an offense already, and what exists that prevents an effective handling of that situation? And what is to say, so if you have the information that a convict who is behind bars is involved in orchestrating crimes on the outside, what has prevented prosecution of them? Have we looked at it? What needs to be in place? Because if they commit an offense,
AG, could I follow that up?
They're liable to prosecution, an additional sentence, and then what do you do? No.
Could I follow that up? To the best of my knowledge, MNS, to the best of my knowledge, most persons who have been convicted and sentenced, if they get a sentence of X, normally they serve 2/3 X. But during their sentence, if they engage in any inappropriate behavior, criminal activity, or involve in any criminal conduct, they lose that 1/3. In other words, they don't get the benefit of that 1/3. Now, the question I want to ask, though, so that 1/3 can be lost if they're engaged in any criminal conduct. I noticed the restrictions don't last for a month. That 1/3 that they 1/3 that they normally get, if they could conditions be imposed on that 1/3, which when they go out, this, I'm not talking about parole, the second 1/3, which could be parole, because normally you'd only serve 2/3.
Minister, so some jurisdiction, it's as part of their sentencing regime. If you get early release, the rest of the sentence still hangs over you.
That's right. That's what I'm asking. Yes.
And conditions are imposed. And if the conditions are met, then you would have passed the sentence time.
Sentence.
If you are in breach, then you can be brought back in. And I think that is part of what you're referring to.
That's correct.
And that is separate and apart from the imposition of a suspended sentence where you do not serve any of the time, but it hangs over you until the occurrence of certain event.
Right.
I don't know.
That's what I'm really asking, is whether this 1/3 in Jamaica is like a suspended sentence which would take that restriction.
No, it doesn't operate that way.
That's
it is
what I'm
part
thinking.
of the correctional institution's process.
No.
And I think that's more administrative.
Get off if you
Is it in the law?
That's when the parole period, that's when you become eligible for parole.
No. After 1/3, you become eligible. So the second 1/3.
It's early release for good behavior.
Early release for good behavior.
Is it in any of the legislation, or it's just a matter of internal administrative matter? It's in the Parole Act itself. Okay.
It's in the Parole Act.
The last 1/3?
Chairman, what I think we need to guard against, this is not the first time we're reviewing a piece of legislation, and the statute books are, full of laws that really have not been effective, whether by way of implementation or otherwise, in tackling the problems. And every time we sit like this, it is our good intention that anything we legislate will bring the results. And we have to now take care that we are not repeating ground already traversed, spend all of this time, and we don't get to the results. So if it is a lack of enforcement or implementation or use of the law, then that does not require re-legislating.
That's right.
If the provisions of an act are no longer sufficient to deal with the extent of the criminality, and with the change in time, technology, we need to revise, then that's another matter. If we're confronted with a new situation which the existing laws have not adequately dealt with, then we look at that. But I'm just a little wary that we come and almost by rote we go through, and they're good sounding and good time is spent, but at the end of the day we're not going to get the real results that we need.
And given that we haven't even had a conviction yet, we have a number of matters that will be coming before the court. Post-conviction is so far away. I think we should be focusing on the things that are going to make a difference in the near term. Such as more effective surveillance tools. And that's been raised in several of the previous meetings, the desire to have some kind of watch list, and there's been a lot of skepticism about its viability. And I think today it has become a little clearer what was actually being asked for in what you were saying. And I think we should perhaps focus on that rather than post-conviction registries.
Chairman, we find ourselves in somewhat uncharted waters in dealing with some of the matters. I think what may be helpful to us is to get an understanding of the existing measures that are used to deal with suspects. Whether we discuss that in camera or in open session is a matter that we can take depending on the sensitivity of the information. Whether those measures are effective, and if they're not effective, what else needs to be done? Do we legislate? Do we continue to provide administratively for some matters? But when we talk about surveillance, and there's a tendency to make a political football of rights issues. You can't go down the road of certain measures without understanding what the implications are. And the rights that are guaranteed are not just the right to liberty and freedom of movement. And if we accept that the challenges we face in respect of monitoring persons suspected of being engaged in certain types of organized criminal activities, and that there are no other effective ways of investigating them to the point where there is evidence to charge them, then we have to embark on another kind of discussion.
I think, well, and I'm sorry, John, to come back. My own view of the discussion we've had in this policy point of view, that this legislation looking at gangs. So I think the first thing what we need to do to carry a lot of it is that we have an organization declared a criminal organization. If the laws we design we think is necessary to be applied to members, individuals that would have to be defined outside of the gang, I think that's a different discussion. What I'm seeing is, what my understanding is that we are looking at an organization, I said, that has been defined as a criminal organization, and you want to track down those who are members of the gang who have been convicted or charged or just defined as a member of the gang. In Canberra, you can demonstrate that they are members of the gang, facilitating or actively involved. That's the three group of people I need to be able to monitor on an ongoing basis. Because even though the gentleman has gone in, he has 2 stages. He gets out on parole because he had been behaving well. He didn't have any reason to do anything in prison. He manages his organization very effectively, so you can monitor him during the time his parole, the rest of his time is on, very easily under existing law. Now, what they see is to bring this all into the Anti-Gang Act. Then when he's finished serving his time, the fact that he remains a member of the gang, I still need to keep track of what he's doing, right? So this is, everything seems to revolve around defining the criminal organization and defining that legally, and then finding a way to identify the members who are of that organization, or members who are the active members or facilitators of the activity of the membership. Does that make legal sense?
I don't know if the issue is one of definition. I think what it sounds to me like you're saying is you want to be able to somehow designate that this enterprise is a criminal enterprise, and from that you want certain consequences to flow. And the consequences are around enhanced surveillance, essentially, right? So the question is, what is a procedure, what's an appropriate procedure for so designating something as a criminal enterprise, given the consequences that you wish to flow from that designation? So if the consequences are serious impingements on constitutional rights, the process of designating normally would be a trial and conviction which involved a finding as an element of the offense that the person was a part of a criminal organization. You're not going that far at this stage. That's not what you're seeking. What you want to be able to do is surveillance, effective surveillance, tracking and so on, to build cases and what have you. So what is involved in that maybe is a less intrusive thing, and so therefore the procedure for how you designate and get permission to treat this is a criminal organization for the purpose of enhanced surveillance, that procedure may not be so burdensome. It may be more easy to access it and so on. And that's the kind of equation I think we're talking about. So you may be that you get a certificate from a senior police officer that such and such, they're satisfied based on their intel that this is a criminal organization. You're not in a position yet to proceed to arrest and charge, but there's a basis for requiring further surveillance, and you want to activate enhanced surveillance measures against the members and facilitators of this organization. And that is a collection of activities which are permitted if that designation is made, whether it be access to financial data, access to phone records, access to tracking, requiring to notify of foreign travel, all of that, which you'd have to work out. And then what's the procedure that, having had that certificate granted, you go before a judge ex parte and make your case, and you get the designation, and then you can proceed. In a nutshell.
Just to sidestep and come back to the issue raised by Member Golding. I gather, Chairman, that the first meeting when the learned DPP was present, no issue was made of the definition of criminal organization. I don't know if that was correct. But, and I'm seeking clarity more than anything else. My understanding, so we've not had any matter that has gone to trial under the anti-gang law. That has gone to trial? Yes. And we've had convictions, or the convictions have only been by way of plea? Just for clarity.
Well, we had 2 convictions by way of plea. Most of the other matters, we didn't find that there were viable cases. So what we did, we charged predicate offenses. But between now and the end of next year, we have about 13, 14 matters. We just completed one, which involved the Pepsi gang, but the witnesses did not come up to proof.
So so the law does not define a gang. Instead, it includes gang as part of the definition of criminal organization.
That is so.
And I just wonder if any challenge has arisen as a result of that. Because I've heard different iterations of the problem from the investigative standpoint before it gets to the prosecutorial, and no doubt would cause you to opine on the soundness of the case to yield a conviction.
Which is why what we have been doing over the last year, we have been working behind the scenes with CTOC,
right,
to try to make sure that at different stages we are ad idem in respect of making sure that there's a viable case. So when we go through these set of cases that we have over the next year, I think we'll be in a very good position by the end of the year to have a body of work that we can draw from. In terms of.
Thank you, DPP. Through you, Chairman. The question may seem, not readily understood, but so what is used to say that a group of persons is a gang?
If they combine together and they are 3 or more persons.
No, I see the definition.
Yeah, so that is the definition is deliberately crafted in this way to capture the idea of persons who come together and associate for the purpose of committing one or more serious offenses, or, as Lim B says, that they are engaged in the issuing of threats of violence, conduct to create fear, intimidate, or exert power, gain influence in communities, or to obtain direct or indirectly financial or material benefits.
I see the definition, but the definition means a gang. So who is the gang? No, the criminal organization. The criminal organization is a certain set of persons who, 3 or more, who are together for certain purposes.
And the whole of the act turns on that. That is what is criminalized by the legislation. Persons coming together in numbers of 3 or more to achieve certain objectives. And once that's the activity, being a member of that organization is illegal.
Maybe I'm not saying it clear.
Maybe.
You don't usually use a word for the meaning of the word. And so, because I'm hearing different problems and they're not materializing, meaning that...
You have a whole bag of cases involving a whole bag of defendants that are about to go before the court.
No, I understand that. I understand the group of persons, 3 or more. No, not at all. But there is. No, it's not me. It's the police who have spoken of certain difficulties.
The police haven't come here and raised that at all. I don't think that you can assume that is to be a challenge until after you've attempted to prosecute the cases and see how the court reacts to it.
It's an issue. It is not an issue, but that is not the information I have.
The DPP officers come here, they've indicated what the issues are to them. They've raised a number of very useful points. Some of them are of general application, some of them are specific to anti-gang legislation. They have a number of cases that are going to be tried shortly, which they presumably feel pass the prosecutorial threshold of being viable. Let us see how they play out in court and whether they can secure convictions.
Turn to the issue of, have we completed the treatment of persons who are convicted? Are we going by the way of an expanded
Before you leave here,
registry?
I want to go back. You raise a interesting for our neighbors. What I see, you're right. There's a criminal organization, and a gang is considered one of the criminal organizations, but there's no definition of a gang here.
There doesn't need to be, because all the attempt is there is to cover any gang, group, alliance, network, combination, or other arrangement. It's any kind of arrangement involving three or more persons. As long as the purpose of it... I'm
seeing a Sean because, as I said...
you would complicate the thing more by adding more definitions of words within a definition.
From my humble point of view, I don't mind. I just want to be sure because I know when the laws get together. Next thing I can't...
You don't need to prove a gang. What you need to prove is that there's a criminal organization. And the gist of it is the coming together of a certain number, minimum of persons to achieve serious criminal objectives, essentially.
That depends on my prosecutor and how they present their case. All right.
In other words, it's evidential. And that is why usually the best evidence is from an ex-gang member. It's evidential. So we really haven't had a problem with that. No problem.
Mr. Richards, you want to continue? See.
Sorry, AG did ask whether or not we had done an assessment of the Criminal Justice Administration Act, and we have not. Empirically, what we have sought to do is to utilize what we thought was a good framework that we could possibly build on. Recall that this register was established principally for monitoring deported persons. So we wanted to see how we could, within the framework of the anti-gang legislation, pull that into operationalization for persons who are being convicted for gang offenses. So as we go to, so I hope that answers your question, AGs, and we will probably try to see if we could get some additional information from the persons at the Ministry of Justice. So for persons who are charged, we have looked at what exists as it relates to the current regime, and we have looked at what exists now under the Bail Act, and Section 2 of the Bail Act actually defines bail in criminal proceedings to mean bail which may be granted A, in or in connection with proceedings for an offense to a person charged with or convicted of the offense, or B, in connection with an offense to a person who is under arrest for the offense, or for whose arrest a warrant endorsed for bail has been issued. Section 6.3 of the Bail Act outlines several conditions when granting bail to a person charged with an offense, to include surrendering their travel documents, informing the court of their intention to leave Jamaica, reporting to the police at specified dates and times, and or requiring the persons to stay at specified locations between specified hours as required by the court. Additionally, Section 6, subsection 6 allows for additional conditions to be imposed upon application by a prosecutor or by a police officer. And Section 6.6 states that where a court has granted bail in criminal proceedings, it may, on application, by or on behalf of the person to whom it was granted, or by the prosecutor or police officer, vary the condition of bail, or where bail was granted unconditionally, impose certain conditions. Section 7.1 states that a court or police officer shall make a record of the decision, and where requested to do so by the defendant, cause a copy of the record of the decision to be given to him as soon as possible after the record is made, or where bail in criminal proceedings granted by endorsing a warrant of arrest, the police officer who releases on bail the person arrested shall make the record required by subsection 1 instead of the judge or the magistrate who has issued the warrant. So for the purposes of the Anti-Gang Act, we are proposing that the following be considered in addition to what is outlined in the Bail Act. So not knowingly associating with known gang members, restriction on the utilization of telecommunication devices, not to possess any restricted items including ballistic vests, restriction on being in specified places, and a requirement to also participate in some social intervention programs. Now, once an individual is charged with any anti-gang offense and admitted to bail, the conditions to be imposed should be included in the gang watch list. And the consequences to flow could include, for example, the disclosure of financial information of the alleged offender. So our recommendation then is really to use the existing frameworks that exist within the Criminal Justice Administration Act for convicted persons, with the extension to gang offenses, and that the additional measures to include not associating with known gang members, restriction on use of telecommunication devices, not possessing restricted items, and also restricting their movement to certain specified places. And I think that would more or less sum up what we have considered in terms of utilizing the existing framework. I must confess that we did spend a great deal of time trying to see how we could incorporate the issue of suspect within a legislative framework outside of covert monitoring from the law enforcement agencies. But it was difficult for us to really decide on whether or not that is something that actually needs to be legislated. I think that would be something for the committee to then discuss.
And that's the end.
Thank you.
Just for clarity, so these proposed conditions would go in the anti-gang law, or they would go in the Bail Act as additional conditions where persons are charged with specified offense, and among the specified offense would be offenses under this law.
Sorry. Consequential amendment to the Bail Act is what we would be proposing.
I need to understand the legal framework. We have the Bail Act and we have conditions for people who have been convicted. We're just applying the restriction and consequence of the Bail Act, or we're going to try and put all these things under the Anti-Gang Act in the kind of mix. I don't know. I need the legal mind's advice. I'm
Chairman, I'm trying to wrap my mind around it, because generally the judge granting bail can impose a number of conditions, and there are guidelines that are set. I mean, if you possess restricted items, those are offenses of and by themselves, because there is a scheme through which certain things come into your possession, and there are restrictions on it. So I'm just trying to make sense.
The Bail Act allows it, but if the person is defined as a member of a gang, we're asking that then special conditions be attached once the judge grants bail. Is that what we're asking here? But there has to be something to link the two. I need to understand. I'm not
but
quite.
Usually, as a matter of practice, the conditions imposed on someone who's been granted bail depends invariably on the type of offense and the antecedents of the person. So if there are, so you have reporting conditions.
That's general. That's in
Yes,
law.
yes.
That once you're getting bail, judge
Right.
can apply conditions. I've had people in my constituency told you cannot go to Glendevon, you must go X place to reside. What I'm getting at is in looking at the anti-gang act, we're trying to put in that once the individual is a member of a gang, we are requiring the judge to impose conditions. Is that what we're trying to do here? As opposed to... Well, the conditions are laid out, whatever, but I'm saying if he's a member of a gang, he or she, then we immediately, the judge is required to impose conditions. Isn't that what we're legislating? Because if the Bail Act has everything in there, what do we need in the anti-gang act? So I need to understand.
Chairman, usually the burden is not on the judge, you know. It's always the police or the prosecutor who would want certain conditions. So to the extent that you would want certain conditions to be imposed on gang members,
I
it
can
is for
understand.
the police to ask for it.
I know, I can understand it, but that's general condition. You know, you get bail, the police or the prosecuting attorney, whoever it is, cannot go to the judge and say, look, I want A, B, and C to be done in this case. But what we are looking at is the anti-gang measure. Isn't it that we are seeking to put within the anti-gang measure that once the individual is identified as a gang member, there'll be a number of conditions that will be imposed on them, almost, yeah, by the judge, as a condition of bail.
You're saying, once they're charged under this act,
yes,
to get bail, you have to...
There'll be enhanced surveillance put on them.
I am kind of grappling, Chairman, with how the judge would determine that a person is a gang member that you mustn't associate with. But pardon my little mind for grappling with it. And if you know that that person is...
No, what I'm going back to is the individual, the criminal organization already defined and established by whether either in having some other member been convicted, and the gang members, the gang is identified. This is Seaward Combo, right? That's the gang that operates from East Avenue. That's their name. Somewhere that must have been established.
Well, the way I see it,
whether in camera or in court, that we have established there's a criminal organization called Seaward, and there are a number of members, and I need to show that you're a member.
Chairman, the only way it could make sense from a practical perspective, going back in the courtroom, you would be charging at least 3 persons under the anti-gang law. So if all the minimum of 3 persons are granted bail, then the condition would have to be that each do not associate with the other, because each is alleged to be a member of an organization. It is only in that context that it could practically make sense.
I need to monitor each of them separately. What I'm looking at is enhanced surveillance. So once he leaves the courtroom, I need to keep track of him and all the associates. Okay.
If I may,
itching to wait.
If I may, when the matters come to court, we have a file. We prepare the allegations. The allegations come from the statements on the file. And usually it asserts that the particular individuals are a member of a named gang. Usually. And just in passing, I would say 98.5% of the matters that have come before the court, at least what we have in the home circuit, nobody has been given bail.
Chairman, just a simple question here. A condition would be don't use any telecommunication device. Do I understand that to be one of the conditions sought? It was on the screen.
Yes, restriction to use of telecommunication devices.
And again, I need my understanding of this whole idea of the watch list.
May I just find out?
No, I'm just saying it. The enhanced surveillance we're looking for will involve electronic devices. Basically, the purpose of what is being placed in the Anti-Gang Act is to be that anyone identified as a member of the criminal organization can be given subject to enhanced surveillance in a legal firm that allows us to use all the evidence.
No, what I understand is there's a condition of bail. That's why I put it in a single. As a condition of bail, that the individual must not use any telecommunications device. Is that what I saw?
Restriction of utilization. Oh, no, that's for.
Can that make sense? So that person lives. It can't. That person lives in a home where they have a landline. Is that regarded as a telecommunications device? And yes, and he lives in this home. So what? Is he to move, or are they to take out the telecommunications device? Which is it? And if the telecommunications device, for example, is being legitimately used.
But Barnum, what I expected is that you could monitor the phone calls on that line.
No, but that can be a condition of bail. You monitor the phone call under a separate legislation. So it doesn't make sense to me.
Sorry,
and then as a condition of bail, don't have any ballistics vest. The judge must put as a condition, John Brown, you must not have a ballistics vest. So a person who went there for wounding with intent, a condition of bail could very well be, John Brown, don't wound anybody else whilst on bail. Makes sense.
No, I was just saying, Minister, that Member Knight is correct. I think the intention really was to look at restricting use of telecommunication devices, but really it is for us to be able to apply the interception of communications to be able to track.
But sir, if you restrict the use, how can you monitor? You can't say I'm restricting the use because I want to monitor. You can monitor whether the person is on bail or not. There's a regime established for that.
Chairman, restriction is not the same as prohibiting the use of it. But perhaps you could say a little more on the kind of restriction that you have in mind for the recommendation.
Richard,
all right. For the restrictions that we're talking about, it's in special circumstances. So, lottery scamming. The person is engaged, or the person was charged, is engaging in a lottery scamming related offense or a cybercrime related offense. So we want to restrict their use of that device to carry out further offenses, right? So in addition to that, an interception warrant.
But would the device have been confiscated as part of the investigation?
Not necessarily.
Okay.
But even if the device is confiscated, are you saying that they must not have access to another device? And how does that come under bail? Don't know.
I see a logic to some of the activities you're trying to restrict. My challenge is, how do you do it? Clearly, if the man is involved in cybercrime, his laptop is his weapon. Cell phone is a lot of scamming. But how do I effectively restrict him on bail? You are now restricted from, limited from use all cell phones? Or each time you need to use a cell phone, you need to report to your probation officer? I mean, how do I?
So, Chairman, if I can answer that, if the restriction is placed on the individual, then if they go to a telecoms provider, take out a device in their name, a SIM card in their name, then the JSF would be alerted. So that is one of the ways of enforcing or policing that condition.
This restriction, not prohibition, but restriction is still...
Is restriction, yes.
So he has to inform the police of any provider who provides him with any such equipment, have to inform the police. But suppose he picks up that laptop in a regular retail shop, he's required to report it to the police, because the retailer would not have a watch list. The telecoms may have a watch list, but the retailer wouldn't, every retailer wouldn't have a watch list.
The provider would, the information will be shared with the telecoms provider. So once he takes it out or uses the device, then they would be alerted, or the intention is for them to be alerted.
Sometimes, Chairman, we have to take things to the absurd in order to understand. And I'm wondering, you tell John Brown you cannot acquire a SIM card. Fine. You tell me that I can acquire a SIM card. I laugh at you. Because the SIM card is to allow the use of this instrument called a cell phone. But Minister Delroy Chuck is a friend of mine. Yes, we've been for years. And if I say to Minister Chuck, no, lend me a cell phone, he's not going to ask me, are you going to send a WhatsApp, a message, or you're going to make a call. He's just going to hand me the instrument, and I use it. So it doesn't, the absurd is, it does not prevent access.
And anybody can go buy it and give you.
And anybody can, you can get it anyway. So don't put into legislation that which cannot, well, you will be putting in something in vain, and the courts don't like to act in vain.
We have to go. That makes a lot of sense. But what I'm saying, the objective in mind is to somehow impair the criminal activity whose weapon is a telecommunication equipment. How do we word this? How do we get this in the law? Because
if the person is using a telephone to carry out criminal activity, what you want to know is, what is this person saying? To whom is this person speaking? So you intercept, and let me tell you, in the JCF, I happen to know that you have some excellent analysts who make connections. So John Brown calls Mary Jane calls Tom Stokes, and that analyst gets all this information from the intelligence gatherers, and then they understand now the web. So it is not a matter of saying don't use a phone. It's a matter of saying intercept and bring into your gossamer those persons who are a part of this enterprise.
Chairman. All right. So let's just for a better understanding, what is the purpose? What is the purpose of restricting the utilization of the Telecommunications Act? To minimize the opportunities to commit another offense or participate in the commission of another offense? But
think you see, you should just put in this section, persons charged under the Criminal Justice Suppression of Criminal Organization Act, special conditions appropriate. Special conditions appropriate to the particular gang member should be imposed. You understand?
But you don't need legislation for that.
Exactly, that's the problem.
Legislation in this regard is to deal with that which now presents a lacuna in the law. But the law as it is can deal with that. So you're acting in a way superfluous. What you're doing? What are you achieving by doing it?
In other words, the existing laws provides opportunity to do the enhanced surveillance in this particular aspect.
Well, beyond that, Chairman, Section 4 of the Bail Act empowers the court with a discretion to deny bail if there are reasons to believe that the defendant would commit an offense while on bail. And if the purpose of restricting the use of the telecoms is to minimize the opportunity for the commission of an offense, then you can go under the wider condition, the wider provision of wanting to restrict. We have to take care to separate out, and I think the DPP had alluded to it, the specificity of the allegations that can be presented to the court to say, in all the circumstances of this case, if the court is minded to grant bail, these are the restrictions that should be placed. We have to separate those from what you would need to legislate for.
When you say separate out what can be done,
meaning that you do not necessarily need an amendment of the law.
Right. That's what I'm trying to do.
Right.
That it appears that I don't need the amendments here. We can proceed to do what we want in terms of providing extensive surveillance on one we feel is involved in certain activities, if they get bail, because most times they will not get bail from what I gather. Is that what we're... Okay. So we would not need any additional legislation to execute this.
But it appears that there is still some concern that the way in which persons are dealt with is not sufficient to manage the risks that are involved with persons charged with offenses under the law. And so my understanding of the presentation is that something more is required. But what more, and what is the justification? And have you considered if the proposal is already properly covered under the existing law? Maybe the DPP can weigh in, if any, if there is anything to add.
The court has a pretty wide ambit in terms of the conditionalities in respect of bail. I don't know if it is in relation to restricted items. You'd want to amend the Bail Act, perhaps, and put a schedule with possible restricted items to give the court a wider, even wider ambit under the Bail Act. And the court can order an individual not to be seen within a certain amount of yards of a community or a location, or not to associate with a particular individual. So I don't know.
If it is that an item is restricted and you possess it, it would stand to reason that you would commit an offense depending on the nature of the restriction. Depending on the nature. So items may be restricted pursuant to law. Or what is the nature of the restriction?
If you restrict me from having a telephone, it does make possession of the telephone a criminal offense. What it does, it would make me breach a condition of bail.
That's what I was trying to get to.
But it's a ridiculous thing, because I'm saying You can't stop John Brown from using a telephone by putting in the law that a condition of his bail ought to be that he doesn't use the phone. That don't make sense.
I ask a question here by any of my learned friends in here, whether on this side or that side. The object of the sign of naming the individuals is that they are part of an established criminal organization already defined by a case or intelligence before a judge, right? We have established that this group from Seaward Heights, posse, is an organized criminal group. But the members of that group, the object is to begin to ensure I can put them on an enhanced surveillance program. Yeah, so what I'm getting here, whether they're on bail or they have been ex-convicts who are still members of the gang, or they are members of the gang we are now just apprehended, we just want to monitor because we have enough intelligence but not necessarily enough. We have enough laws, you say, in the existing approach. That's what I'm trying to clarify. So in fact, we can in fact define the watch list of gang members with existing legislation. That's the real question.
Chairman, the truth is,
this bit of leisure has been active now for about what? When was it? When it was passed? When?
Yeah, but Chairman, let me just say this.
No.
The main concentration should be persons suspected.
2014. Yeah.
The main concentration. The main concentration should be persons suspected, which here again is more surveillance, more.
No. The suspect is being done by the intelligence operators.
That is correct. More intelligence.
When you get that point that you can move to evidence, so I'm trying to build. So
no, right. But what I'm really saying is that persons charged, you have all the opportunity to keep that person under total control. If the person is not in prison, is not on bail, if you put that person in bail, you have total control still.
I want to identify persons who we can identify as a member of a criminal organization.
Yes.
Who may fall, they fall in tricky. There are those who have gone to court. They come out, but they still remain members, so you want to keep track of them.
Yes.
There are those who are just charging. So they might be in prison or they might be on out, or you still have to monitor. And there are those who you can say are members, and this is where the challenge will come. We can go before a judge and say, this man's a member of SeaWorld crew, but he's not yet charged. All I'm doing, so I'm saying, so those are the three groups, and I'm going to put them on, and all of them can go on enhanced surveillance. Do I need new legislation for that?
No, I don't think so.
No, Chairman.
Exactly. No, I'm just asking. I'm asking. So,
Chairman, let's look at this thing logically. Right. You suspect X of carrying out some illegal activity, and X is someone who is carrying out that activity the use of a telephone. Scamming. My understanding of the law as it exists is that an order can be sought and obtained.
I'm hearing you loud and clear. What I'm saying is that...
And whether the person be a member of a gang or a member of a choir, you can use the existing law. It doesn't matter.
What was being suggested before you came?
I heard.
And was that yes, these exist already, right? So you can go get an intercept order. You could go and get access to bank information if you thought that there was some money laundering going on by going. The idea was, would it be useful in the gang context to have one procedure that would give you a range of surveillance options? So you would be able to get the intercepts, access to information concerning financial transactions through the banking system, and any reporting on moving across borders.
Let's
you'd have one, you'd get a clutch of one procedure.
In relation, for example, to the banking, that's done often by the parish judge. But as I understand the interception, that's done by a Supreme Court judge. So is either now you want the parish judge to start to deal with interception, or you're going to say that the Supreme Court judge must deal with banking.
No, so how I envisaged it was it would be a Supreme Court procedure which would be under the anti-gang legislation for enhanced surveillance of gang-related suspects. You go before the judge, you provide fairly compelling ex parte evidence that there is this going on, and you get a surveillance order.
So it's just a
procedure. A procedure that gives you a certain menu of remedies, which would include bank records, intercept, and crossing the border, like if the person's leaving the country, that there would be a report triggered that PICA would have to report to the police.
But PICA can do that now.
Yeah.
PICA, look here, when someone is leaving,
it can all be done now.
When someone is leaving the island, unless they're leaving from some surreptitious airport, something,
or
boat or something, it's public knowledge, They're the public record.
Where?
You don't need any law to get that public record, At the airport.
How you access that record?
You don't travel, or you travel in some big ways?
No.
Look here.
No. I don't travel.
I was listening to the.
No, I'm a layman,
before.
I need a little clarification.
I just want to know, what is it? Point out to me, and I will be on your side. What is it that you want to do that no law now exists to permit you to do it?
That you have raised. Simple thing. Individual CD goes to the airport. I expect his name is flagged. Immediately he gets to the airport, it generates a report to CTOG or MOCA or somebody, right? And no, you said the law don't exist for him to do that, right? But that can be done for anybody that defined in several areas. What you're looking at, I need that anybody from my SeaWorld crew goes to the airport that comes up, whether they have been convicted or not. Once they are identified as a member of SeaWorld,
it can happen.
This can be
That's
done.
what a stop order is.
No, and that's putting a stop order on them.
That's what a stop
No
order
stop order.
is. I have a client right now.
No, I don't want a stop
who
order.
was subject to
All I
a
want is
stop order. He wasn't charged with any offense.
No,
but when he went to the airport, he couldn't travel.
No, I know a stop order can be done. I'm just saying, what we are looking at is a series of things, and I phoned your colleague, leading a direction I could understand. Once we define the gang, all members of that organization will be monitored by the state apparatus. Completely. And you're saying enough law is here to do that now in a comprehensive manner.
You define gang, garden house, and you have some names there. Is that proof?
No.
All I want to do is that if Garden House gang is a criminal group, all the members of Garden House.
Says who?
No. The judge will tell me that before. That's what we went to.
The judge is going to tell you under what circumstances.
No, that is the prosecutor's problem. What I have as the police officer is that now I have Garden House as a criminal organization.
Yes.
And therefore every single member who has gotten there will now be put on a list that will allow my other officers to check his bank account. When him go to the airport, his name come up immediately on his SS red flag. I can tap his phone throughout, and when him drive from here to Montego Bay, I can tell the police if they see him on the road, the camera pass through the camera at 3:30. It sends a signal to my fusion center immediately.
What prevents that now?
I'm asking if that's possible now without any change in law.
It's possible, but it would require a series of steps to
Right.
achieve that.
Right.
That comprehensive range of surveillance
Right.
would require a series of different steps to be followed.
And
So
what you're
all I
suggesting?
was suggesting was it might
Put it
be
in this, yeah.
useful to have a concept of enhanced surveillance,
Right.
which is available by way of a court order obtained
Right.
ex parte,
Oh.
which the police, you would set out the threshold for obtaining it.
Would we then put that as new legislation as part
It
of
would
the
have to
anti-gang
be
law?
a high
Or
threshold.
as a consequence of being a member of a gang, you invoke this as a piece of legislation? Is that possible in law?
No.
It's
but-
just surveillance. It's
no,
nothing. It's
but
nothing
listen,
else.
Let's understand. So, the police put together a list and say there is a God house gang. Doesn't make it a gang,
Correct.
and does not make those all
We have gone
persons
beyond that.
there
No, we have
to
gone
be
beyond that.
members of it.
No, we have gone beyond that.
Listen,
God house gang
let
is
me
a
tell you-
no.
No,
We have gone beyond that. You're taking me backward. I want to go forward.
no, I'm not taking you.
Yes, because I have a definition that God house is a criminal organization.
and
That's settled.
that definition is by the police.
No.
Who? The
We have
judge?
gone through the process to define it as a criminal organization
And
in
who,
law.
who accepts that it is?
It was before a judge.
You going before a judge for the judge to say, yes, this is a gang? Look here, man.
No, it couldn't work. It couldn't work. I don't think the judge could definitively say that this is a gang. What the judge would say is that based on what is before me, the police have indicated that this is a criminal organization for which enhanced surveillance is required in the interest of the public. What enhanced surveillance entails must be something that is not so impinging on the rights of the citizen that to grant an order allowing it to
I'm with you
happen
there
would
now.
be
The conflict is, do I
unconstitutional.
need legislation or do I have enough legislation to proceed? No. Your colleague is saying I need nothing. He's saying I cannot define a criminal organization. I'm saying the law is there to, my understanding as a layperson is that this piece of legislation was put in place to define criminal organization. I have a criminal organization. I need to I need to monitor the organization. Do I need additional legislation to do that? I have the criminal organization defined. By whatever means, you'd have to tell me. I'd be advised by that.
Sorry, if I may, through you, Chair. As a part of the JCF submissions, we had proposed that there be a provision which allows an application to be made to the court to satisfy a judge that there's reasonable cause to believe that an entity is a criminal organization. So that would not be to the criminal standard for the purposes of any criminal prosecution. It is a concept that's in the Proceeds of Crime Act and also in the FID Act, reasonable cause to believe. And then once the judge is satisfied that an organization is a criminal organization, certain consequences can flow. For example, we can be able to access financial records of the persons who we say are members, and that is a similar concept under the Terrorism Prevention Act now. So I think that is a regime that can be looked at to be further developed to see what additional, if it is surveillance activities that can flow as a consequence from that.
That is that I have a defined criminal organization. My learned colleagues raised the issue. How do you define them? I thought this is what this law was about. That we have
Not a definitional issue. The issue really is what are the measures that flow from that designation by the court. Reasonable cause to believe that's a fairly low threshold in the scheme of things. So what is permissible presently under some legislation is access to financial records, right? But for your purposes, I got the impression you wanted a more general surveillance, a more general menu of surveillance options that would enable you for a period, in my view, it should be a finite period of time that you mustn't use it and get the evidence to charge within that, and it ends.
I'm with you in one there that this is the purpose, is once the member can be identified as part of a criminal-like organization, individual, whether it is once above 3, whether it is 3 or 50, I have the police authority with a legal firm to now introduce all of these surveillance measures, from financial records to intercept to crossing the border and all that to moving from one place to the other.
Well, the key is what are those measures? That's very, very important, because each one of them must be proportionate to the fact that all you've done is gone before a judge and said you have reasonable cause to believe that this guy is a member of a criminal organization. And the court has accepted that for the purpose of allowing you to do some surveillance. The question is, what types of surveillance are within a reasonably proportionate balance to the process that you've gone through to establish that the surveillance should be allowed?
You have to advise me.
Yes.
It seems to me that we're having a fixation on gangs. And
Organization, criminal organization.
Same thing. Yeah. And maybe we have to just drift away from it a bit and make a fixation on criminals. So if you look...
I don't want to drift, because the object of this is to deal with gangs, which is our principal challenge in the criminal network.
Gangs are made up of criminals. Right. And when you see, this is where I'm thinking you're going wrong, because you're not getting an order against an organization. No. You're getting an order against individuals. It's individuals. Right. That's why I'm saying have your fixation on criminals. What can the state do to monitor a criminal? Well, and once you settle in your mind the options available, then now you say, well, in the situation of an organization, all I'm doing is multiplying or adding to the numbers. Instead of 1, it's 5. Yeah. But the procedure, the process has been settled. It is applicable to 1 as it is to 15. You now, in your investigative process and your intelligence gathering, you have them together. So you monitor now the movement and behavior of a group for your purposes. When you go to, when the police now go to the DPP's office, she's looking at it from a different perspective. What is this evidence showing? What are these statements showing? How do I lead this evidence? What can I do with it, etc., etc.? But if you start from this fixation on gang, then you're going to have a difficulty. That's how I see it. I might be totally wrong.
So let us say you're going from the point, you're focusing on the individual as a criminal, and then you're multiplying or adding those numbers, so you've gone to 3 or more, right? And you think that they operate in tandem, so to speak, so that they do their criminality with each other. So what you want to know is, all right, what is the surveillance tools that are reasonably available to...
Let's not reinvent the wheel. Before we had this thing on gangs, we had cartels that are dealt with in other jurisdictions, drug cartels.
Same thing.
It's the same, just different things they deal with.
Yeah. And some of these gangs do that too.
Exactly. So I have never heard of any interception against a cartel.
No.
But I have heard about interception against Pablo Escobar.
Yeah. So what I'm saying is, we have gentlemen, we have A, B, C, and D. And you've heard that they are the A2 gang, let us say. You want to be able to watch surveillance on them in the form of intercept, in the form of banking information, and you want to trigger, you want a decision that PICA recognizes that if they see this person leaving, they have to notify CTOC or whoever, MOCA or whoever it is. And that's 3 of them, maybe there's some others. Now, to get all of that done currently, there are different channels you have to go through for each. I thought what you wanted was a procedure under the anti-gang legislation that says A, B, and C we think R&D or we think are part of this organization. We just want to have for all four of them. It doesn't matter. The focus is not on the organization. It's on A, B, C, and D.
No, but you just said A, B, C, and D are members of this organization.
Because that is what brings them under this act. That you're planning, you're intending at some point through the surveillance to charge them under this act. Yeah.
That is my understanding of the watch list for gangs. But my colleague, in a different context.
I am trying to help.
I know my colleague is not a criminal lawyer.
I'm certainly not a criminal lawyer. But I can see the benefit. I can see the benefit in fighting organized crime. Organized crime is allegedly responsible for 60% plus of the murders in the country. That is what the police have been saying for some time, right? We have an anti-gang legislation. We have a criminal organization piece of legislation. You want a facility to allow enhanced surveillance so you can better investigate and prepare cases. That's what this is about, this discussion, right? All I'm trying to say is currently the law allows for these different forms of surveillance in disparate ways. And I was only suggesting that there might be useful to legislate a mechanism that would allow you to have all of those benefits in relation to any individual that you're planning to or hoping to charge under this act. Whether it's one person or it's 5 or it's 20. That's all I'm trying to do, you know.
No, you're perfectly right there. You're speaking now, since it's criminal law, like layperson with legal experience. So I'm in tune with what you're saying. But I'm hearing a different approach where that there are challenges being raised by the legal minds who have been involved in prosecution. So I need to hear how to deal with them, because what you have said is pretty much what they're looking at. A2 gang is identified by virtue of the police, maybe one even have been gone to prison, but the others are brought forward. We have enough intel to say this is A2 gang, A, B, C, D, and I'm going to put all of them on all the required enhanced surveillance I want. I need to go to no other act except the Anti-Gang Act.
May I just ask a question? If you have reason to believe that John Brown is associating with Tom Stroke and AB, in order to proceed, do you need to have minimum information about the association among the three of them? Or do you, if you have information about John Brown and you want to proceed against John Brown and you want to find out who John Brown is associated with, what is he doing, you go under this or you go under a general piece of legislation? Meaning, exactly. So when you come here, you are coming here with a minimum that there are at least 3 persons who are associating for the purpose of criminal enterprise. Huh? Right. But that is the threshold that you have to cross. But if there is one, this doesn't really apply.
One would have to, I'd have to demonstrate that the one is associated with the 3. That is where again, right?
Investigating all 3.
What I mean, you have the 3 that is part of a criminal organization. My police response is to prove that John Brown has linkages with one or more of the 3, which has now been defined as an organization. Okay, thank you. All right. So now, because the evidence, there's in the minimum evidence demonstrated he has connection, therefore he now becomes subject to the same level of surveillance that A, B, and C is going through.
Interest is against all who are associating or against one? Right, that's my understanding.
Once John Brown is seen to be identified, is in connection with A, B, and C, he becomes part of a network. And if E and F begins to talk to John Brown and see they too become part of the.
You convict a single person for being part of a gang here without the evidence as to who the other people are?
Not before you
That's
have
right.
identified other members of the gang. Those things.
Let me just. When I was in second form, 2A at Woolman's, I had a maths teacher named Mrs. Banks. And I was there one day arguing, fussing around and thing, and Mrs. Banks looked at me and I've never forgotten it. She said, Knight, don't imagine difficulties. Chairman, don't imagine difficulties. It can be done as the law exists. I would like to be told where, when, how, why, that efforts have been made to deal with this, but they have come to naught because of the existing law. That's what I'd like to know. If the answer is in the negative, then where you know that they have no example of it. You use what you have.
Yeah, what I'm asking then, what is the difficulty? You see, I'm just trying to get an answer. Technically, what I understand you're saying to me, I can tomorrow morning administratively instruct the police that once they've identified any member of this community that they have a high level of suspicion or enough intelligence to demonstrate they are a member of the particular gang what we have identified. We have take up, all right, let's take a gang. We have 7 members of X gang in a particular parish incarcerated. The police can then proceed to put all the other members of the gang that are known under special surveillance. I can put their name on a list and say, anyway these guys show up, I need to inform CTOC. Can I do that by current law?
I don't know about the power of the minister to involve
No, I'm not. The police, I am not using my power. I'm saying I can ask the police who has the power and the responsibility to monitor the gangs, in particular CTOC then.
But
Mocha.
they can, they know they can, they do it.
No, I want it done in a framework I can use it to gather evidence.
But they have done it. They have done it. Why do you think some people have been extradited from this country?
We have had no watch list in the country officially for ever.
But watch list is just a name. You watch people. It started legislatively under, I think we used to call it the deportee legislation, the Criminal Justice Administration. Persons commit offenses abroad, they come home, and you can make certain designations as to where they live and reporting to the police and so on. That's a different regime. We've been, look here, this wheel has existed for years. We've been monitoring people. We've been watching people. We've been stopping people from traveling. We've been looking at people's bank accounts. We've been doing a lot of these things. So it is not that it has not happened. So I don't know if it is the absence of the tools why we haven't achieved the end we want, or it is something else. But if you have a hoe that works, don't go buy a new one. It's a waste of money.
Chair, could I just answer the Honorable Attorney General, was querying about one person being part of a gang. Section 6, subsection 1. And in fact, we do have matters where we have one person. So all you do, you lead evidence to show the existence of the gang and why is it that this person is a member of this criminal organization.
I can understand that. I'm trying to get at that once you have a one individual, you have to show that they're a member of the criminal organization. So what I'm getting, the law now allows me. What law allows me, what the member is saying, I don't need any new legislation to put all members of the known members of a particular criminal organization and a formal list that goes to the airport, goes to CETA, goes to wherever else I'm going, and say, look, these people, if any one of them show up at the airport, it raises a red flag. If you appear at the airport outside the country and biometric shows the same person, a red flag comes up. That is technically what they're getting into. The law currently allows me to do that with them. I can call the FID grouping in finance and say, look, check all of these guys. Or ladies and gentlemen.
When you say I can call, because I am very
I, as a minister, don't be confused it, right?
No. Because I'm very, very sensitive to ministerial intervention.
No, you don't need a procedure. When I say that, clearly it is the police involvement. I'm just the personalizing now, but I have nothing to do with that. But the prosecuting attorney or the police in charge of such matters can then proceed to track, right? Lawyers the police investigating the case.
Maybe somebody
may do that.
Maybe somebody can tell us how is a stop order obtained? Because I know that the police, they do it. A court can do it.
No.
The police do it every day.
No, a stop order. A stop order can only be court ordered. A stop order is part of the conditions of bail usually, and it is court ordered. The police authorities, because they are a paramilitary organization, can have stop orders technically on a watch list for their members who may have contravened some administrative protocol, or they may be suspected of committing a crime. The police can do that in respect of their rank structure, but it's only the court that can make a stop order. Only the court.
Go get it.
Chairman, just to get back on track. So the committee is considering whether there is need to impose additional conditions other than those already specified in the Bail Act for persons charged with offenses under the Criminal Justice Suppression of Criminal Organization. And a number of recommendations have been made and deliberated upon. And it appears to be the thinking of the committee that insofar as the specified recommendations are concerned, those are already covered by provisions of the Bail Act.
The Bail Act is part of two proposals here which we're trying to deal with.
No, in respect of persons who are charged.
Yeah,
first.
But
we have the other issue of persons who are suspected and what to do with them up to the point where you gather sufficient evidence to charge them or no longer have an interest in them. That's a separate thing. But just to bring some conclusion to how we treat with those who are charged and are granted bail, whether there is need to amend the Bail Act to have additional conditions specified. That is.
Well, the impression I'm getting, the Bail Act gives the judge a very wide ambit.
Yes.
It's up to once you get to that point, it's up to the prosecuting law to make a request for what they want.
So the thinking is that insofar as what is required, the provisions of the law allow for conditions to be specified that would cover the recommendations?
Sorry, I think we had acknowledged that the judge has a very wide power in granting bail to impose whatever conditions the judge thinks fit. However, I think that our mindset was that it may be prudent for persons charged with this type of offenses for the legislation to highlight that in considering bail, a judge should consider whether any of some listed provisions should be imposed. So it will bring the judge's mind to, all right, you're charged for this, let me look to see whether or not necessarily prompted by the police, but just on the judge's own understanding of the allegations. Let me look to this list to see what would be appropriate.
Permissible.
I'm told that the persons who have been charged so far have not been granted bail. Almost have not. But you know that when conditions are set out, for example, in a Bail Act, one of the reasons for setting out those conditions is to give the judge a wider discretion to offer the person bail. And you offer the person because these options are available to ensure, well, as far as one can, that the person will not commit an offense. You know that. So, for example, when you put in these conditions and defense lawyer says, milady, if you impose this, then there is a greater likelihood that John Brown will turn up for his trial, so on and so on. So I'm sure that perhaps there are some defense counsel who wouldn't mind some of these conditions, in that there would be perhaps a greater likelihood of their clients.
But with respect, member, are you completed? I'm sorry, you're through. The problem with gang matters, it's not just about a question of turning up for your trial. There is a very, very high rate of witness intimidation and witness interference. It is part and parcel. And in fact, in the case that was just completed with the Burger Gully gang, where the Crown was no-cased, the witnesses did not come up to proof. And 3 out of, was it 7, were on bail. 3 of them were on bail.
I don't want to try that case in here because I've heard different interpretations.
No, I will specify. Let's use the principle involved, member. What we are looking at specifically this legislative with gang criminal organization members who are involved in all kinds of things, including murder. And what they're looking for is special circumstances in the case where bail, where they're charged, wonder what condition they should be bailed. Do we need to, I think the question being asked, do we need added legislation or do we just allow existing legislation to be used by the judge at the judge's discretion?
If I may,
it's not broke, but if, as you proceed, you may need to give direction to the judges.
Chair, yes.
Basically what I'm getting from there, that times are changing and legislation have to be amended or expanded or added to our legislative armor to deal with issues.
Chair, if I may, there's one of the items proposed under Proposal 1, I notice, in relation to persons convicted, is the wearing of electronic monitoring devices. I note that their Proposal 2 in relation to persons charged, this was not repeated. I am aware that for some years now the Ministry of National Security has been considering the rollout or deployment of electronic monitoring for persons who are charged, and I also believe for persons who may be released on license, like for parole. I would think that that is something very concrete and practical that could be done and would then help with the monitoring of suspects, well, persons charged and persons already convicted. Perhaps the ministry could speak to their position in relation to that.
It has been started in a limited way.
Started for years.
No, it has.
What you want to know is when is it going to be finished?
We have started for persons on parole. I know there's already a regime in law to deal with persons on bail, but we haven't acquired any electronic resources really.
A contract. To come to the monitor, that's your electronic monitoring.
Electronic monitoring for persons on parole.
No, these
Not
are people.
for persons
These are
on
low.
bail.
No. Well, that electronic monitoring, but for people who are low risk prisoners, it can be expanded.
There's equipment, she's saying, for parolees. The Bail Act provides for electronic monitoring, but you don't have the equipment. And that's for high risk, because you don't monitor low risk people. You monitor high risk. No, but they still get bail. They get bail. Remember, we are a constitutional democracy.
My DPP has been able to successfully avoid bail for quite the high risk criminals for a while now.
Well,
but some of them do escape and cause problems.
Just to wrap up the presentation from this standpoint, so the committee has considered the recommendation, and also that although from all indications persons generally are not granted bail, where the court is minded to grant bail, to specify certain additional conditions that could be considered among the recommendation, among those recommended.
Thank you very much, Ed. I think the real thing, we don't want to spend the entire day, we could look at briefly, is it those who are suspected, have a high level of suspicion of being members and active members of criminal organization?
Chairman, I think it may be useful for us to get an understanding of the existing tools that are used to monitor persons who are suspected of committing offenses. How much of that monitoring is done pursuant to legislation, how much of it is done pursuant to administrative actions, and to see where the gaps are and what else that needs to be done, or whether there is need to formalize the processes and the mechanisms that are used. Whether that discussion takes place openly or in camera, as we have done for other, it can be determined. Because I don't know that it is generally known what the menu of tools are that are used. Some are known, some are not known for the monitoring of persons until there is evidence to charge them or for there to be no longer any interest in them.
Your comment, or you want to, without the person, well, the police?
Chairman, we know that applications can be made under the Interception of Communications Act, and there is a whole regime there. We know that the police uses wanted persons list, and there are various other things just to get an idea and see how we pull all together.
I have to ask the police to come back on that because I don't have that. I don't have that kind of data currently available. But yes, there's a number of different things used to monitor highly suspected criminal activists in the criminal organization.
So, just to shift from that to help with the completion. So the other proposal was to how to deal with persons who are convicted, and the recommendation is to amend the register of restricted persons to make specific provisions for those who have been convicted under the law. Right.
That was already done. It was a consequential amendment to the Anti-Gang Act. What?
Right. No, that's but that's in the general registry of restricted persons.
Yes.
I thought you were saying that
a subset
right.
of that will now be known as the watch list. Remember, the policy imperative.
But what you're watching them for?
Certain consequences would flow basically from being named on a watch list, like enhanced surveillance. Remember, all these proposals are in aid of establishing a watch list, a gang watch list, which is the policy imperative.
Just a mischievous question, very mischievous. If someone is designated as a gang member and it's publicized and that individual can show that he or she is not, is there some remedy available? There is.
There's a review tribunal under the Criminal Justice Administration Act. But remember this now, that person would actually know that they are named on a watch list. For the suspected persons, I don't know if it is that the person should know that they're on a list, because then it defeats the purpose.
We had pulled a set of amendments out of the ZOSO law that were proposed amendments to the anti-gang with a view to delaying until this review takes place. Have we brought them up? Because there was a provision for that when we're looking at the monitoring, pre-charge monitoring, how to deal with them if there is no longer any reason to believe that they are involved in the activities and they themselves could make an application to be severed from the process. So where is that as part of this regime?
So we did consider all of the provisions that were actually included in the ZOSO bill. Before coming to Parliament this afternoon, we agreed that just to establish the factors for suspicion, whether or not those that really needs to be legislated, we really were grappling with how it is that we'll be able to implement that kind of framework.
If you check the Hansard, at the time when the bill was debated, it was a decision of the Parliament that that aspect of the consequential amendment would have been severed and be considered at the time of review. So you just double check and see. So it wouldn't be for it to be looked at and left in the ministry, but for it to be brought forward and looked at as part of the proposal for the review of the law.
So that is something that with the
we have it here.
Well, we do actually have it here. It was not presented as part of the package to the committee members, but we could go through it if the chairman so directs.
And in here?
Sorry.
Here you go.
No, I'm saying that we do have it as part of our previous presentation, so we could go through it
what the amendments that were removed from the Zozo law actually brought here?
Correct, yes.
You did mention in the very early presentation.
Of control orders, yes.
You did mention them very early in the game. I think the very first presentation you had.
Because that would deal specifically with suspects.
I don't think the AG was here.
Yeah.
No, they were considered. They were considered. Where is it?
All right.
We
What?
didn't go through in detail. Or did? Yeah.
There's also one.
If you'd like for us to go through again, it's no problem.
Before you go into that, I think they were circulated at the very beginning of the session. It may suit us to go to the papers again and take a look at them. I don't to start them this evening. That might be a little bit extended, but I think the point the AG has raised, I think, is of value. We should ask the police to provide us with that kind of data. What are the current means of surveillance used where there's a high level of suspicion? What can you use by the approval of senior police officer? What can you approve going to court? Am I right? There are a series of activities. And if we get a sense of that, we know whether we need to get new legislation or just apply what we have. Huh?
Is there any need for new legislation? And if they say yes, then let them propose. If they say no...
So, Ms. White, you can have
Yes,
discussion
Chair.
with your officers and let's see if we go there. All right?
Yes, Chair.
And Mocha as well, Chairman. Yeah, just
At
put
each other.
Mocha on.
Two heads. Now, all right. The discussion is what prevents you from making mistakes and bringing unnecessary new legislation. All right? So it was useful. I don't think we can do much more today on this issue. The minutes have been circulated for all the meetings. When I ask members to go through them, they come to comment. Only for two. Yeah, as the minutes come out, we won't convene again until the new year. Today is the, you want to meet next week? You'll have us, I think there's an office down Duke Street that we could meet. DP, do they agree with it? That's why I'm suggesting that it would be a good, appropriate circumstance environment in which to have a meeting. And I'm sure that that office can afford a little bit more than the cake and sorrel as well. We won't say what else.
I can't afford the kind of cakes I see being bought these days. I don't have it.
You won't take it today. Well, let me thank the members.
Excuse me, Chair, just
Any
before you,
question?
just for clarity, the tools that we are being asked to provide, will they be discussed in camera?
No, it doesn't.
You're going to discuss with them and then to find out from them if they, having regard to the tools they are using, if they need any legislative enhancement.
Discuss it among yourselves, and you think you need legislation to strengthen that and expand the capacity of the forces, rather than bringing them here for discussion.
Thank you for
So
the
you can so
clarification.
inform us at the next meeting. I agree with you. We don't want to get into those details at this point. Let me thank everyone. And since this was some interesting sitting for me, almost a learning experience in the seat, right? And very interesting piece of legislation. But let me thank everybody. It's pre-Christmas, so I think I have to take the opportunity to wish all of you a very holy and peaceful and safe season. Return next year healthy and maybe a little bit heavier, but we'll work it out in due course. And then, diary, so we don't end up. Yes, we have. What dates are we having here now? January.
These are already locked off in the morning.
Tuesday, so the only free times we have would be
Wednesdays?
Wednesdays in the afternoon.
Wednesday afternoons? Three first Wednesdays. Afternoon.
You said you do first three.
No, I'm just saying I won't be here on the 16th.
9th, 16th, and 23rd. Any?
Just giving an apology from now for the 16th of January. I'll be away.
Thank you. Then,
all the best to you too, and all the best to you too for the season.
It's your colleague that gave me the trouble and keep his people quiet over in Portmore. I'll visit him there if you want.
So sorry, the next.
I would like to see every crime finish in Jamaica, and the children them, oh boy, it would be a happy world for them. Jamaica is very beautiful and nice, you know. There is nowhere like home. This place is paradise, you know. It's just the crime that really keeping us scared. Let's create a safer Jamaica.
A message from the Ministry of National Security.
Keep we island clean, so clean. From the peaks to the beach, so clean. No dirty up Jamaica, please don't do it. Keep we island clean, so clean. From the peaks to the beach, so clean. No dirty up Jamaica,